record or transmit any aspect of these proceedings. Motions.
No, Your Honor. I spoke to counsel and had indicated it was going to be our intention to address it at the sidebar. If the court wishes, I will file that and we can address it.
It's appropriate to address it at the sidebar, and if I should be recused, then I think it's something you should raise now and I should rule on before dealing with the other matters.
Respectfully, Your Honor, we learned about this sometime around 11:30 this morning. Mr. McCauley called me and told me they were planning on raising this issue at today's hearing, and he then sent me by email at 11:47 a memorandum of law in support of, I guess, a motion to recuse.
Which has not been shared yet with the court.
That's correct, Your Honor. Apparently not. Frankly, Your Honor, I mean, this is a serious matter, and if the court is going to entertain the motion, if it's filed, I would like an opportunity to respond in writing and to have a hearing on the motion rather than have to essentially respond in a vacuum, which is the position that we're put in by having this matter raised at the last minute. So unless the court is prepared to deny it summarily, I would respectfully request an opportunity to respond in writing.
I can't deny it summarily without hearing it.
Well, I agree, Your Honor, but I'm not prepared.
Well, I'm fully prepared today to hear it and hear any response and to rule immediately. But if you wish the matter to be that motion to be addressed at another time.
Well, Your Honor, to the extent that, I mean, based on, again, the court hasn't seen the memo that I've seen. I'm not prepared to address either the facts or the alleged facts or the law set forth in that memorandum because we have not had any opportunity to. I have the applicable cases with me, but I've read them very quickly, and I don't think it's fair for me to have to argue the merits of such an important motion without having an opportunity to respond.
Since the court was received its special assignment on September 12th, it was docketed on September 17th. Is there any reason the Commonwealth has waited for close to a month before raising but not filing, even at this time, a motion to recuse? And also the court, as I'm sure you are aware, because from the docket sheet you are listed as lead counsel in another case, Commonwealth versus Wallace, and the court went forward on that. District Attorney Sutter was there. No motion to recuse was filed in that case. Is there any explanation for why all these days and weeks have gone by and all of a sudden now this is being raised? And wasn't raised even yesterday when counsel was contacted as to what was going to be on for today?
Your Honor, I learned of the assignment, the special assignment, that Your Honor would be on this case when I was in the middle of a murder case down the hall. That was brought to my attention by a member of the press who had approached me and was seeking a comment on what I thought about that. I made no comment at that time. I was engaged in that murder case for the next 2 weeks, and the jury was being instructed when the court was here with Ernest Wallace. So I was unavailable dealing with a 2 co-defendant murder case when these matters were raised. The Commonwealth obviously does not take lightly the filing of a motion to recuse. I had filed, as Your Honor well knows, we tried a case, the Commonwealth versus George Duarte, 2010.
Are you arguing the motion at this time, or are you
well,
just...
if Your Honor...
My question was simply why you've waited.
I was explaining that I've waited because I was engaged in a murder case and I had not had an opportunity to review the transcript, to go back, and I've done that since the last time that the matter was before the court. And as I say, this isn't a matter the Commonwealth takes lightly, but I've reviewed that and refreshed my memory about that trial, Commonwealth versus George Duarte. And Your Honor will well remember that a year later, in the spring of 2011, Your Honor was assigned to a case. I was the lead prosecutor in that case, and I filed a motion to recuse. And at that time, that motion was not addressed by the court. It was sent to a different judge. So I never had the opportunity to argue the motion as to why I didn't think Your Honor should be the appropriate judge in this case based on the background of what had occurred in the last trial that I was involved in. So today, and again, because it wasn't dealt with lightly, I spoke to counsel. The decision was made to try and avoid a situation that would compound the issue that the Commonwealth sought on recusal. And I suggested, I thought the best way to do that would be go to the sidebar and take this up with the court, so that it didn't essentially, that we were talking about what had happened in the past, and that...
I don't see any, I don't believe it's appropriate to take up the issue of a judge's recusal from a case based on the reasons that the government is articulating at sidebar. I think that to the extent the Commonwealth has reasons and the defendant has a position, I don't see it as a matter that should be taken up out of the hearing of the public, but at the request of the defendant to have this heard at a future time. We will schedule at a future time, and I will go to the first matter that we have on scheduled for today. There were a couple
Your Honor, if I could just add to that when I did speak to my brother earlier today, and I told him about the motion and what I intended, he was in full agreement with that. So again, this isn't trying to spring something on him or the
full
court.
agreement with what?
With going to the sidebar and approaching Your Honor with this issue, so that his motion was filed because he's concerned about media exacerbation of this case. And so I indicated that this is an attempt to avoid needlessly.
The motion that was filed for an order deals with extrajudicial statements. There's been no motion that this court should close any proceedings in this case or any motions. The motion that I've been handed up is in a different case. Is this Durand? Is this the motion you...
That was the motion that's attached, Your Honor. That was the motion filed. There's a motion for recusal, and it references the motion that I filed in the Durand case.
Okay, I don't see a motion for recusal that's been handed up. Maybe there's one yet to be filed. What's been handed up is the Commonwealth's motion for recusal filed in an unrelated case and a memorandum in support. If you'd like, we will schedule this for hearing.
Your Honor, let me just make one correction. What I told Mr. McCauley this morning when he told me he would plan to raise this issue of recusal at sidebar, as I said, you can raise whatever you want to raise at sidebar, and I will take a position on behalf of the defendant. And just to be clear, Your Honor, we intend to object in the strongest terms to any motion to recuse, Your Honor. I just want to be in a position to articulate a reasonable, coherent legal argument in opposition to that motion.
We'll schedule it.
Thank you.
The next motion is, I guess there are a couple. Do you want me to take up the...
Your Honor, before the court takes up the motions, could Mr. Hernandez's handcuffs be removed during the hearing?
Yes.
Thank you, Your Honor. and
just before we leave that, when do you intend to actually file the motion for recusal? Because what's been handed up is a memorandum and a motion filed in an unrelated case. Is there a motion that you actually have with you?
Yes, Your Honor.
Maybe you could hand that up as well.
And we'll be happy to respond in writing within a week, Your Honor, or whatever the court says.
I'm sorry, Your Honor, if I could file that, I'll file that this afternoon. I believe that's downstairs. Thank you.
Do you want to, should we take up first the motion on extrajudicial statements?
Yes, Your Honor, thank you. And this is a motion which was originally filed on the date of arraignment, Your Honor. It was argued before Judge McIntyre. On that date, the Commonwealth indicated that it wanted to file a written response, and basically the parties agreed that paragraph 5 of the, paragraph 5 of our proposed order, which is attached to the motion would be in effect pending further proceedings on the motion. So that's what's happened so far, Your Honor. I think, Your Honor, the motion is fairly self-explanatory. We have, in this case,
To the
since
extent paragraph 5 really also tracks your paragraph, paragraph 1 and 2, I mean, it doesn't appear as if any of the other preceding paragraphs go further than the rules either.
Well, Your Honor, I think in terms of the proposed order,
Right.
I mean, I think my effort I agree with Your Honor about paragraphs 1 and 2. Paragraph 3 was an effort to specify, because I think that the language of the professional rule is somewhat amorphous. It was an attempt to identify some of our specific concerns based on the material which has been leaked into the media, just a torrent of it, since Mr. Hernandez first appeared in court, in this case, on June 26th. And so that was my reason for seeking relief beyond simply, let's just comply with professional rules. I think that this is a case which requires some stronger involvement of the court in limiting extrajudicial statements, because I think Mr. Hernandez's right to a fair trial has already been substantially impaired, and I simply want to try to prevent future damage based on extrajudicial statements. And I'm not necessarily, Your Honor, pointing the finger at the prosecutors per se, but there are a lot of people working for the prosecution in this case, and many of the articles, including some that I've submitted as exhibits to the motion, refer to law enforcement officials, law enforcement sources, never identified, but whatever the sources are, to the extent that the court and the parties can stop this kind of undermining of the defendant's constitutional right to a fair trial, I think that should take place. And unfortunately, a lot of damage has been done already, but it doesn't mean that we shouldn't put a stop to it now if we can.
Thank you. Which one of you, Ms. Bummer?
Good afternoon, Your Honor. I think, as we've just sort of simply stated in our response, Your Honor, is that the professional rules of conduct do apply. They have been adhered to. Nothing in the attachments from counsel, I'm going to suggest that the court indicate anything other than that.
Well, one of them has indicates that law enforcement sources say there are several theories. One is that Lloyd mouthed off to Hernandez about secrets Hernandez had told him involving involvement in drugs and several violent incidents. The theory is Hernandez went ballistic after Lloyd started throwing damaging information in Hernandez's face, information Hernandez thought would end his relationship with his fiancée and his football career. Is that something that's ever been discussed in any arraignment or in any public
not that I'm aware of.
And what steps did you, and by you I mean your office, take any steps to investigate who those law enforcement sources may have been? And
well, Your Honor, the fact of the matter is that the discussion's never been had as described there. That these what we do know is repeatedly blind sourcing to law enforcement sources has resulted in the reporting of things that are just blatantly not true. And it's happened repeatedly. And it's been an overwhelming indication to the Commonwealth, Your Honor, that in fact these blind sources aren't associated with the investigation. There was a repeated, for days, reporting that there was a warrant for Mr. Hernandez's arrest on a theory that doesn't exist in the Commonwealth attributed to law enforcement sources. And much of what has been reported, and in fact, I could, if the court was inclined, I could go back and find articles describing that investigators have, repeatedly describing investigators as being tight-lipped, that what we've observed over a period.
But was that, for example, those particular comments attributed to law enforcement officials investigated?
We haven't investigated that particular issue because it never happened, Your Honor.
What never happened? That the law
What
enforcement
was-
officials never said it?
No, insofar as the investigation and investigators goes, what is attributed to law enforcement officials hasn't occurred within the investigation. And so,
But what steps have you taken to advise law enforcement officials connected with the investigation?
we have, Your
their
Honor,
responsibilities.
repeatedly met with, as the court probably would infer, the police officers and the people involved in the investigation. We have ourselves repeatedly emphasized that nothing, that no information was to be discussed outside of the investigation. So we've done it from the beginning. We have done it on a basis that I wouldn't say it's regular in the sense that it's scheduled or anything, but we have repeatedly reminded investigators, Your Honor, of the importance associated with exactly the issue that the court has raised.
And with respect to information not contained in a public record that falls within A through E, to the extent the defendant is seeking to make somewhat more specific the rules to the extent, although that doesn't have within it the rules which say which allow dissemination of information contained in a public record. So with that, to the extent that was incorporated in it, does the Commonwealth agree that it should not be making extrajudicial statements of the kind set forth in A through E, unless they're in, unless it's something explicitly permitted by the rules, such as statements made in a public record?
If I understand what the court is saying, I don't believe that there's any issue with that from the Commonwealth's perspective.
That you agree that you could not be saying these things if they weren't in the
Exactly,
public
Your
record?
Honor. Our real issue involves really two things, if I may, Your Honor. Really, paragraph number 4, it seems to the Commonwealth that does not capture any aspect of the rules of professional conduct, and that it is essentially nebulous, and it almost provides for a circumstance in which counsel would be out with the ability to say that they have expectations of hope of anything as long as they don't support it with anything, with any factual basis. And I don't think that that serves any purpose associated with the rules. Further, Your Honor, we, as the court would, if you issued this order, the idea that there are attributions to just, again, law enforcement sources without any further description, this blind sourcing, I think creates an untenable circumstance, and at the same time provides for any person who is blind sourced, and I don't, again, just as Mr. Sultan has said, attribute anything to defense counsel, but that's just blind sourced as associated with Mr. Hernandez, they'd be free to say anything they want. I just think that in the circumstances, that does not serve any purpose consistent with the rules, and the rules themselves, Your Honor, should be the source of the controlling authority.
Thank you. I do plan to issue a written decision, but at this time I will explain my reasons. The defendant seeks an order that will prevent counsel for each party or their agents from making extrajudicial statements to the media that would have a substantial likelihood of materially prejudicing potential jurors or witnesses. The case has generated significant media attention, and there are several newspaper reports that attribute statements to unnamed law enforcement sources. Undoubtedly, there is a legitimate interest in protecting the integrity and fairness of the state's judicial system, and in order to further the state's interests in fair trials, speech by attorneys representing clients in pending cases may be regulated under a standard less demanding than clear and present danger of actual prejudice or imminent threat. Proof of a substantial likelihood of material prejudice satisfies the First Amendment. Whether or not the court issues the requested order, significant continued publicity appears to be inevitable given the intense interest in this and related cases and the publicly available records as well as the public proceedings that have occurred and will continue to occur. As the Supreme Judicial Court has recognized, pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. Jury selection is likely months away, and a searching voir dire will be able to ferret out persons who cannot be fair and impartial because of pretrial publicity. More importantly, the order being sought would in effect require the parties to comply with Supreme Judicial Court Rule 3.07, the Massachusetts Rules of Professional Conduct, and the parties have stipulated that they will be bound by this rule. At this stage, and I emphasize at this stage, the Massachusetts Rules of Professional Conduct constitute the least restrictive alternative. In relevant part, Rule 3.6 states a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that a reasonable person would expect to be disseminated by means of a public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. A lawyer, however, is permitted under the rule to state, among other things, the offense or defense involved, the information contained in a public record, that an investigation of the matter is in progress, and the scheduling or result of any step in litigation. The rule also provides that no lawyer associated in a firm or government agency with a lawyer subject to the rule shall make a statement prohibited by the rule. In addition to this rule that applies both to defense counsel and to prosecutors, Rule 3.8 of the Rules of Professional Conduct impose additional responsibilities on a prosecutor. It requires a prosecutor to exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with a prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6. It also provides that a prosecutor shall accept for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. In other words, according to the commentary, a prosecutor can and should avoid comments which have no legitimate law enforcement purpose and have a substantial likelihood of increasing public opprobrium of the accused. The Commonwealth agrees here not only to follow the rules, but further agrees that it would be a violation of the rules to reveal the prior criminal record of the character, background, reputation, or prior bad acts of the defendant or any co-defendant, the existence or contents of any statements made by the defendant or any co-defendant to any law enforcement personnel, or the refusal or failure of the defendant or any co-defendant to make any statements to law enforcement personnel, the results of any forensic testing, the prior statements or credibility of any prospective witness, and the substance of any evidence any party anticipates seeking to introduce at trial, unless the prosecutor is permitted to make those statements because, for example, it is information contained in a public record. If counsel, in this case, flout these rules, they may be subject to disciplinary action. The discipline for such a violation ranges from admonition by bar counsel to disbarment. I conclude that at this time, the rules of professional conduct coupled with admonitions from the court render it unnecessary to issue an order that would hold out the prospect of enforcing a violation of the rules by way of civil and criminal contempt. A substantial likelihood that without the threat of contempt, the Commonwealth will violate its obligations under the rules of professional conduct has not been shown at this time. The reasons for issuing an order may, however, become more compelling as trial nears and if the rules are ignored. Failure to issue an order at this time should not be deemed to constitute any endorsement by this court of counsel trying this case in the media or allowing their agents to do so. As the United States Supreme Court stated in 1941, legal trials are not like elections, to be won through the use of the meeting hall, the radio, and the newspaper, and today one would add through television or social media. Any attorney who is participating or who has participated in the investigation or litigation of this matter is strongly admonished by the court to read and to comply with Rule 3.6 and to take steps, preferably in writing, to remind any lawyer associated in a firm or government agency with such an attorney that the lawyer cannot make a statement prohibited by 3.6a. In addition, any lawyer who is participating or who has participated in the investigation or litigation of this matter as a prosecutor is strongly admonished by the court to read and to comply with Rule 3.8g and to exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6, preferably by explaining the prohibition in writing to such persons and warning of disciplinary consequences should they make an on or off-the-record statement in violation of the rule. For these reasons, at this time, the defendant's motion for an order prohibiting prejudicial extrajudicial statements of counsel and their agents is denied, and it is denied without a prejudice. There is a motion as well to preserve evidence. I guess it was indicated previous judge ruled on the first paragraph, you said, but not the second.
Your Honor, what she did, looking at the endorsement, Judge McIntyre allowed the first paragraph. The second paragraph she denied without prejudice. As my recollection is that the Commonwealth indicated that it wanted some time to address the ramifications of the second paragraph of the motion to preserve, but I would ask that the court hear at this time.
Why don't I hear first then from the Commonwealth, and then I'll let you respond, because maybe there's no disagreement at this point.
Well, the judge then, after the hearing, Your Honor, Judge McIntyre then denied the second paragraph without prejudice. So, to the extent that the defendant is renewing that, Your Honor, I'm going to suggest to the court that that request is without basis in the law. The defendant cites a couple of cases, I think, in support, generally speaking, of the idea of the issue of loss of potentially exculpatory evidence, but specifically, Your Honor, the defendant cites to Commonwealth versus Charles on the issue of general proposition. That case and the line of cases that follow after Charles have actually been superseded by a case, Commonwealth versus Williams, Your Honor, 455 Mass 706, a 2010 case, and it's relevant specifically to the defendant's request because the defendant, Your Honor, is requesting that the Commonwealth now engage in an investigation, essentially, and report back to the defendant whether or not there has been any such issue. In the case of Commonwealth versus Williams, as I've indicated to the court, places the initial burden of raising the issue and making the claim on the defendant.
To the extent that Commonwealth is aware that a piece of physical evidence that they had, they lost, or limiting, to the extent this motion is very broad, refers to any notes, refers to anything, limiting it to the automatic discovery requirements. So the recorded statements of a defendant or a co-defendant, or recorded statements of a person who testified before a going jury, and relevant police reports. I mean, what you're required to provide an automatic discovery. To the extent the Commonwealth is let's take it in two parts. To the extent you're actually aware that you go for police reports and you see, gee, one would expect to have a police report for this date, and you ask the police, do you really not have any police report for this date? And they say, we had one, but it's been wiped out of our computer, it's been destroyed. To the extent you're actually aware of missing physical evidence or any statements, any objection to disclosing that?
No, Your Honor. To that extent, no. So I agree with the court. As we work through it, and maybe this, I don't want to necessarily move on to a different topic, but we are in the process, Your Honor, of turning over all of the discovery. We've been doing that on a fairly consistent basis since the arraignment, and if we do come across something that we're missing, Your Honor, I'd be happy to highlight that to counsel.
So to the extent you're aware that a piece of
Right.
evidence has been destroyed or
Right.
missing,
Yes, Your Honor.
you would highlight that.
Yes, Your
And
Honor.
you're saying you simply shouldn't have to go back to everyone to ask.
Well, as we work through
As you work through, I mean, as you work through getting this evidence, presumably you're talking to the law
Right.
enforcement officials to get in order to get the material and relevant police reports, photographs, tangible objects, reports of physical exams, etc. You presumably are going to law enforcement officials and saying, give me what you have.
Correct.
And would it be all of that more onerous to say, and let me know if any of this has been destroyed?
Correct. As to that, as we work through that mandatory discovery, there's no issue as the court's described.
Both to making the inquiry of the persons from whom you're getting the mandatory discovery for those materials, and making the further inquiry to the extent you're not giving me anything, is it because you've lost or destroyed anything?
I don't have any issue with that as the court's
Thank you.
described,
Well, Your Honor, I think that's pretty
That's
much
pretty much what
what
you-
we're asking for.
Right.
I mean, I'm not asking them to do a
Word in a different way, but I think it is.
investigation. If they're aware that there's evidence that's missing, they should tell us what it is, what happened to it, and why it was lost or destroyed. I think that the case, I mean, again, we don't have a written filing. I don't have Williams with me, but as I recall, Williams is about a claim of lost evidence. We're not here claiming there is lost evidence. We're saying, if there is any lost evidence, tell us what it is, and tell us when it was lost and why it was lost. And I think that the court has sort of rephrased that request, but to me, it's there's nothing unreasonable about it, and it really is necessary for us to have that information, really, because the information may well be exculpatory. I don't see any reason why that information should be hidden from the defense.
So what I'm going to do is enter an order ordering the Commonwealth to disclose to the defendant whether any automatic discovery has been destroyed, lost, or altered when and if it becomes aware of such, and further order the Commonwealth to request of the law enforcement officials or others from whom it is seeking said material whether any of the automatic discovery has been destroyed, lost, or altered, and if so, to provide the details, which seems to capture the essence of paragraph 2. Jill, can I? This one. No. This. This you could put denied for the reasons stated on the record. Denied without prejudice. That one I'm going to need. Mr. Bomberg had filed a notice at the beginning of the trial. Is there a, at this time or at some time, do counsel want the court to engage in any sort of colloquy with respect to representation?
I'm sorry, Your Honor, I don't understand the question.
Mr. Bomberg filed a notice at the beginning of the trial pursuant to Commonwealth versus Crokin. Do you want the court to engage in a colloquy today or at some time in the future?
Your Honor, we're prepared to do that today if the court wants to do that today.
I would like to just hear from I would just like to hear from counsel before I do that. I mean, you've done the arguments today, and you've
right, could Mr. Fee address that particular
right.
subject?
I would just really like Mr. Fee to address what his, so I have a sense before I do the colloquy, what his role is in the case, and then I will. I may ask you some additional questions as the colloquy goes on, but I assume you want me to engage in a colloquy as to having Mr. Fee continue to represent Mr. Hernandez.
That's correct, Your Honor, and that's really a joint desire of Mr. Bomberg
right.
and I. And my role is co-counsel for Mr. Hernandez in the case. And the issue that Mr. Bomberg and I jointly wanted to bring to the attention of the court at some point, and this is as good as any, does implicate Commonwealth versus Crokin in that Mr. Bomberg's wife is a partner at my law firm.
Would you describe yourself as an intimate or close friend of his wife, sort of beyond sort of social, beyond firm events that you socialize?
Well, I like to think I get along with everyone, Your Honor,
right.
And I would say we are friendly, but Ms. Bomberg works in a completely separate floor, completely different practice area. Not someone I see on a regular basis. I might see her periodically, maybe once every 3 or 4 months in the perhaps in the lunchroom. Not someone I work with. We don't share cases. We don't share anything. Our firm has also...
And that's been true in the past, too.
Correct, Your Honor. That's always been the case. I can also say that our firm has taken steps with Ms. Bomberg's complete cooperation to segregate her both electronically and physically from any access to any evidence or any work product that may be generated by myself or others working on Mr. Hernandez's behalf at the firm. I'd couple that with a disclosure that both myself and my partner, Mr. Jones, made to Mr. Hernandez it was our first actual encounter with Mr. Bomberg, knowing Mr. Bomberg's presence on the case on June 17th. And we disclosed the status of ADA Bomberg's wife as being a partner in the firm. Mr. Hernandez expressed no objection, understood that, subsequently confirmed that in a written disclosure, Your Honor, that we executed, and I'd be happy to share with the court. If necessary, Mr. Bomberg is aware of that written disclosure as well. And we feel that under the circumstances, with the immediate and timely disclosure of the status to Mr. Hernandez back in June, with the cooperation that has been exhibited by Mr. Bomberg and myself, and steps we've taken in our firm We feel we've complied with Commonwealth versus Crook, and we feel that there has been complete and full disclosure, and we do think for the record that it would be important for a brief colloquy to be conducted with the defendant so that Mr. Hernandez can confirm what I've told the court.
Thank you. Mr. Hernandez may take the stand. And Mrs. Sultan, do you want to stand next to him? Or?
Thank you, Your Honor. Yeah.
I'll stand back. You stand back. Yeah.
Solemnly swear the evidence you give to the court, the matter now in hearing should be the truth, the whole truth, and nothing but the truth, so help you God. Be seated, please.
Mr. Hernandez, a question has been raised regarding whether your attorney, Mr. Fee, might have a potential conflict of interest that could affect his representation of you, and for that reason, it's important that we make sure that you have a fully and informed and voluntary choice about who represents you in this matter. So in order to be sure that you understand completely what that choice could mean to you, I'm going to ask you some questions. If at any time you have any difficulty hearing or understanding any of the questions, let me know. And if at any point you want to talk to your attorney, Ms. Sultan, who's standing right next to you, you're free to do that. Could you please state your name?
Aaron Hernandez,
And your age?
23,
And how far did you go in school?
3 years of college.
Do you have any trouble speaking or understanding English?
No,
And what has been your employment?
I played football, NFL.
Have you ever been treated for mental illness?
No,
Are you aware of any mental illness you may now have?
no,
Have you taken any medication within the last 24 hours?
no,
Are you under the influence of any drugs or alcohol?
no,
Do you understand in this case you have been charged with murder, unlawful possession of a firearm, 4 charges, and unlawful possession of a large capacity firearm?
yes,
And have you discussed the meaning of these charges and the elements of these offenses with your attorneys?
yes,
Do you understand if you were to be convicted of murder in the first degree, the sentence the judge would be required to impose is life in prison without any possibility of parole?
yes,
And you understand the maximum penalty for the charge of unlawful possession of a firearm under Section 10A of Chapter 269 is 5 years in state prison with a minimum mandatory of no less than 18 months.
yes,
And you understand the maximum penalty for each of the 3 charges of unlawful possession of a firearm under Section 10H is 2 years in a house of correction.
yes,
And you understand the maximum penalty for the charge of unlawful possession of a large capacity firearm is 10 years in state prison with a minimum mandatory of no less than 2.5 years.
yes,
And you further understand that sentences can be imposed consecutively.
yes,
You have a right under the Constitution to be represented by an attorney who is fully on your side and able to represent you without any conflicting loyalties. This means you have the right to be represented by a lawyer who is free of any conflict of interest and whose commitment is solely to you. Do you understand that?
yes,
You have the right to be fully informed of any conflicts that might exist and to waive any such potential conflict and to continue to be represented by this attorney, or if you prefer, to have a different attorney. Do you understand that?
yes,
An attorney has a duty to do his best to advance the interests of his clients. Do you understand this?
yes,
In this case, I have been informed that ADA Bomberg's wife is a partner at Ropes & Gray, where your attorney, Mr. Fee, is also a partner. Are you aware of that?
yes,
A lawyer's personal interest may include an interest in maintaining friendly relations with his law firm partners. This interest conceivably might bear on how he goes about making decisions. Do you understand that there may be circumstances that could potentially give rise to a situation in which your attorney may have an incentive to do something that might be inconsistent with your interests or not to do something that would be in your interest?
I'm aware.
Did you hear what Mr. Fee told to the court with respect to the nature of his relationship with ADA Bomberg's wife?
Yes,
Mr. Fee, have you concluded that your representation of Mr. Hernandez will not be adversely affected by the fact that ADA Bomberg's wife is your partner?
I have, Your Honor.
And are there any facts or any is there any greater detail of a potential conflict that you would like to put on the record than the court has set forth?
No, Your Honor, other than then the potential for that conflict was disclosed to Mr. Hernandez immediately upon our encounter with Mr. Palmer on June 17th.
Did you hear what was said by your attorney?
Yes.
And do you understand why there could appear to be a potential conflict of interest?
Yes.
Did you speak, as Mr. Feast stated, with him about this issue?
Yes.
You're also being represented in this case by Mr. Rankin and Mr. Sultan, who are with a different law firm. Did you talk to either or both of them about this issue?
Yes.
And did you talk to them without Mr. Fee being present?
Yes.
Do you understand you're entitled to have your attorney keep your confidences and not disclose to anyone else any confidential information you have with him?
Yes.
Knowing all this and knowing that a potential conflict may exist if Mr. Fee represents you in this matter, do you choose to continue to be represented by Attorney Fee as co-counsel in this case, or do you prefer to have a different attorney in addition to Mrs. Rankin and Sultan, or no attorney at all in addition to them? Do you wish Mr. Fee to continue to represent you?
Yes, Your Honor.
Did you make that choice on your own, freely and voluntarily, without any pressure or inducement or threat of any kind?
Yes.
Has anyone threatened you or made any promises to you of reward or anything otherwise regarding your decision to keep Attorney Fee as counsel?
No.
Have you understood all the questions I've asked you?
Yes.
Is there anything that you wish to ask at this time of any of your counsel?
No, Your Honor.
Despite making this choice, it's possible that circumstances could develop in the future that would cause your attorney to be required to withdraw from your case because of an actual conflict of interest. Do you understand that?
Yes.
If at this time you choose to proceed with this attorney and to waive any potential conflict that may exist, and if you are ultimately convicted and you appeal from that conviction, you will not then be able to raise on appeal the issue of your attorney's potential conflict of interest because that issue will be held to have been waived. Do you understand that?
Yes.
At this point, having heard all of these explanations and understanding all these matters, do you feel that you are fully informed, so you're able to make this decision?
Yes.
Have you had enough time to think about it and to discuss it with your attorneys or with anyone else whose advice you might want?
Yes.
And what is your choice at this time?
To remain my lawyer, Mr. Fee.
Thank you. You may step down.
Thank you.
Thank you, Your Honor.
Thank you.
I find that the defendant is not presently suffering from any mental illness or condition, that he understands the seriousness of the charges against him and understands the circumstances of having Attorney Fee represent him in this case, and has decided to have Attorney Fee represent him as co-counsel on these indictments. Further, I find the defendant has been fully advised of any potential conflicts that Attorney Fee may have, and that he fully understands the right that he is waiving and the consequences of his waiver, and the court finds the defendant made this waiver voluntarily, intelligently, and unknowingly. That appears to be all the motions that court is aware of. And in terms of discovery, what's been providing of automatic discovery, I assume that's an ongoing matter.
It is, Your Honor, and we discussed amongst the council, Your Honor, the date of December 6th for essentially the conclusion of that between now and then we would look to provide all of the automatic discovery in cases.
Is it too early for you to know whether there are going to be certain substantive motions filed that we could now schedule, or would you rather wait till the
Well,
conclusion?
Your Honor, there will be substantive motions,
Right.
but frankly, given the massive size of the discovery we're getting, I would, if the court permits it, I think it makes a lot more sense to deal with the case in pieces, and the first piece is to complete discovery, and then set a schedule for substantive motions.
Should we bring you back in on December 6th for sort of status of...
I think that's fine, Your Honor. If Your Honor wants to hear the Commonwealth recusal motion.
I will do
before
that before then, but let's first, in
I think
terms
that would
of
be helpful, Your Honor,
discovery.
yeah.
Oh, yes, actually, the court is, there's a all-court meeting on that day, so, thanks. But the following Friday, 13th?
That's fine, Your Honor. Friday the 13th. December.
For sort of pre-trial
The
conference,
status RE discovery?
status discovery and scheduling
Yes, sir.
future motions. Do you want the defendant at that hearing?
Your Honor, given the gravity of the charges, we would ask that the court permit him to be here for all hearings.
You may.
Thank you. Would that be at 2 o'clock, Your Honor? Or-
It will be at, let's make it 2:30. I'm coming up from Dedham. For now, I've been using this courtroom. I don't want to disrupt the trial sessions, and it's marginally bigger. So you should assume that the sessions will be in this courtroom. Let's also schedule a hearing on the recusal motion. Which I understand will be filed today. So I don't know how much time you want it to.
7 days would be sufficient, Your Honor, to respond.
So that's by the 16th. 21st in the afternoon?
That's fine, Your Honor.
So December 6th for discovery status, October 21 at 2:30 on the motion to recuse. I noticed that you were contacted yesterday by two different session clerks regarding what was to be heard today. To avoid that happening in the future, Clerk Santos has designated the session clerk in courtroom 6, which is the session where I generally sit for 6 months of the year, to be the point person for this case.
Who is that?
That at present, that clerk is Mark Ferreira. So as the session clerk in that session may change from time to time, it will be whoever is the session clerk. And that should be the person with whom you should deal and the person who will be contacting you when necessary. If anything is to be filed, I would ask that you send a courtesy copy to me in Dedham. Also, if you have it by email, if you email it to Mr. Ferreira or any succeeding courtroom 6 session clerk, that person will forward the email brief or memo to me.
So just in terms of what Your Honor just said, Your Honor's going to be in Dedham for the next
I
few months?
anticipate, well, I'm definitely in Dedham October through December. We don't have our assignments for next year yet, but I anticipate it is likely that I will be in Dedham January through March.
So
as
anything
well.
filed between certainly now and the end of the year, the court wants a courtesy copy in Dedham.
Yes.
Thank you.
But if you do it by email, I don't need the hard copy in Dedham. But as I say, I anticipate being in Dedham through March. Different session, but in Dedham. Anything else? Anything else?
Oh, Your Honor, that's it?
No, Your Honor, thank you.
Thank you very much.
All right.
I can't find who it is, I'll call your attention. Was that Hernandez?
Yeah, I pulled the code off. That's Mr.
Thank you very much.
It's not my style.
Hey. I think we're reaching the time in.
Sorry.
I know. I tried to tell her, it's not anybody's fault, it's a big boy. Yeah, so I'll keep it, I got enough to do, what I do, so I'll tell her what to do. No, I saw the one, yeah. Brian, how are you, hon? Good.
Let me know, is everybody ready now?
He's gone.
Gone. I wanted to eat lunch before I.
Yeah, he's up to the house.
Will all rise? He. All persons having anything to do before the Honorable, the Justice Susan Guy of the Superior Court, now sitting at Fall River within and for the Commonwealth. Join in. Give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. Be seated, please.